Typically what we'll do if we're going to represent more than one client is we're going to do a engagement letter retainer agreement, which is going to reference and incorporate by reference a separate writing in which we do our conflict disclosure and waiver. I don't know if we're just being grammatically fussy about making it pretty, but that's the way we like to do it. That's the way I would recommend doing it. In writing is pretty much the magic word. Whenever you're going to do something that's slightly iffy and under the rules of professional conduct, you have to make your disclosure and get the consent in writing. Now, there's some question as to whether in a world of electronic communication, whether that actually means a wet signature on a piece of paper, but when the consequences of being wrong are so severe, I don't much feel like sticking my neck out and arguing that point. If it says in writing, I'm actually going to go old school and get a piece of paper and a pen. Other people who are less risk averse might conclude otherwise, but that's for you to decide.
Joel, just a question for you. What about things like conflict waivers, guarantees, things of that nature? Would you include them in your retainer agreement, or would those be separate documents? And
typically what we'll do if we're going to represent more than one client is we're going to do a engagement letter retainer agreement, which is going to reference and incorporate by reference a separate writing in which we do our conflict disclosure and waiver. I don't know if we're just being grammatically fussy about making it pretty, but that's the way we like to do it. That's the way I would recommend doing it. There are other ways to do it. I mean, there's as many ways to do it as there are lawyers sitting in this room. But we prefer in our practice to keep the documents separate, although incorporate them by reference to each other.
Right. For no other reason, maybe some evidentiary reasons to keep those documents separate?
Yeah, there might be.
Yeah. Moving on to scope of engagement.
Okay, scope of engagement. We were having a conversation with one of your colleagues this evening about scope of engagement. This is, I think, one of the top important parts of any agreement. It defines what you're contracting to do, what you're going to be obligated to do, what you're going to be responsible for having done or not done if you screw up. And it's as important for how you define what you're going to do as it is for what you carve out. Some obvious carve-outs. I've already admitted to you I don't know anything about tax. So every one of our retainer agreements includes a carve-out saying, look, we are not responsible for advising you as to the tax consequences of anything that happens in any of the litigation that we undertake. We will have carve-outs if we're being engaged.
Bankruptcy, appeals.
Well, we don't do that. We don't.
Maritime.
There's a remarkable amount of things that we don't actually know how to do, even if we sue people for them.
It's staggering what we don't know.
But also, we'll carve out whether or not whether we're engaging for a litigation matter or a pre-litigation matter. Sometimes we will require a separate agreement if a pre-litigation engagement turns into litigation. We will frequently carve out appellate processes. It's not like we don't do them, but there are people who are probably better at it than we are, and we don't want to engage universally saying that we're going to do it. The other thing is that we spend some effort trying to actually describe with particularity what it is that we're going to do. And this all goes back to that basic conservative paranoia that's the hallmark of my personal practice. I don't want to inadvertently be responsible for something that I haven't thought of, that I didn't intend to do. So I try to define what it is I'm going to do very carefully. And in the years in which I was mostly a defense lawyer, I've used that with some success when people say, well, aha. In fact, almost 20 years ago, my dear friend in the back and I were on the opposite sides of a case. She was actually the opposing expert, where the issue was my client had done some franchise work for this company, and the plaintiffs wanted to say, well, you were actually advising us about the merits of our business plan and what we could and shouldn't do. And we're going, no, we're not. We're the franchise lawyers. You guys get to make your own business decisions. Well, if I'm engaging with a client, I want to be able to control what it is I'm responsible for and what it is I'm not responsible for. I'm just the dumb litigator. I'm not here to tell you whether your business plan is good or not. unless I actually am that person, in which case that's what I'll say in my scope of engagement. So again, in terms of the document being your best friend, this is one of the key provisions. And again, not unlike conflict checking, it's not a one and done. Things change. There are times when it's necessary for you to change the scope of engagement. Our retainer agreements say that the changes must be done in writing. We don't want some casual conversation to be interpreted as saying that, well, we talked about this once. Remember, we were at the cocktail party, and that thereby expands what we've agreed to do. No, if you want to change our scope of engagement, that's fine. We can talk about it. We can negotiate it, but we're going to do it in writing.
Okay, prevailing party attorney's fees clauses. Oh, we have a question. Oh.
If the scope of engagement changes, do you enter into a whole new fulsome retainer agreement at that point, or is there a way to kind of add, like, do an addendum or an amendment or something like that, just to do, because obviously that happens a lot.
We don't require the entire thing be done, a novation of the whole agreement, but we do require there be a writing that memorializes the change. And again, just because we do it one way doesn't mean that you can't go back and do it the other way. There's as many ways to do things as there are people in this room. But for us, in our practice, as long as there's some writing that memorializes that change, it's good enough for us.
Okay. Yeah, we'll do a little bit of a lightning round here so we can get to, I know you want to get to that other thing there. So one of the top disputes in the hit parade, disputes between attorneys and clients regarding fees. Good risk management practice would suggest that you give prevailing party attorney's fees clauses every due consideration. To be honest, it's more of a business decision. In fact, don't even know if I'd classify it so much as a legal or ethical issue, but something you at least want to consider when you're drafting your retainer agreements. It can be a double-edged sword. There are certainly pros and cons to including such an agreement. Ours currently has one for the most part, but again, every time we take on a new client, we're going to be looking through our retainer agreement. We're not just going to fill in a few things. We're going to make sure we define our client. We're going to make sure we define our scope and carve out the things we're not doing. And we're going to go through the areas that we need to go through and spend just a few minutes on the retainer agreement to protect ourselves downstream. Certainly, there's some benefits to using a prevailing party's attorney's fees clause. You can obviously give, again, in the example I guess I'm talking about, any disputes with clients over fees could give the parties pause to file any frivolous claims. But it's certainly a means of effectively collecting unpaid fees. I mean, obviously, the worry is the expense of chasing a client or former client for fees is going to eat up any potential recovery you may have. So it's certainly enticing from that perspective. But there are certainly disadvantages. You can enumerate a few of them here. And the reality is, I think that pacified by the promise of potential pie-in-the-sky fees, it can really encourage the other side, rather perhaps our ex-client and their new attorneys, to spend more than perhaps they otherwise would, because they see a pot of gold at the end of the rainbow with the prospect of obtaining their fees back. And you should keep in mind that, when going after your fees, that's almost invariably going to bring back against you, potential claims of legal malpractice and whatnot, some of which we have listed up here for some of the potential disadvantages. But even if the claims are largely defeated or reduced, even a minimal net recovery by your client could potentially cost you as far as the attorney's fees go.